and get started, even though the in-person totals have not arrived. Maybe there will be fewer people that signed up, but I am told that the previous program is running a little late. But we're going to go ahead and start so that we don't back into the next program. In any event, I would like to welcome you to what has become an annual tradition here at New York Arbitration Week. It's a Oxford-style debates on high-tech issues of interest. And the program is sponsored by the Silicon Valley Arbitration and Mediation Center, more commonly known as SVAMC. And for those of you not familiar with SVAMC, it's a nonprofit organization that promotes arbitration of high-tech matters. And it maintains a website, which I encourage you to visit, www.svamc.org. And on this website, aside from articles of interest in the high-tech field, it maintains a list of the world's leading high-tech arbitrators. This is a vetted invitation-only list, and I strongly encourage you next time you have a high-tech matter of any nature to go check out their resumes, because you'll find someone with every kind of technological specialty. Also, I just should add, don't be fooled by the name SVAMC. It started in Silicon Valley, but we have arbitrators all over the world. All of us who are participating in this program today are from New York, myself included. We have arbitrators throughout the US, South America, Europe, Asia. It's not just a Silicon Valley entity. So without further ado, I'm going to introduce very briefly our panelists. Briefly, because A, if you go to svamc.org, you'll find their full resumes. B, if you're on the virtual program and you tap on their names, it's hyperlinked to their resumes. But I'll say just a few words. Dr. Cheryl Agris, who's sitting immediately to my right, in addition to being a very experienced arbitrator, she's a registered patent attorney and has been involved in the IP field for over 30 years. She is currently a partner in Agris and von Natzmer, whose practice includes all aspects of IP, with an emphasis on biotechnology, pharmaceutical, and chemical patent matters. She is on the panels of World Intellectual Property Organization, WIPO, and the AAA, among many others. In addition to her law degree, she holds a PhD in biochemistry from Johns Hopkins University. Mr. Graff is sitting next to her, George Graff. For more than 50 years, George has arbitrated, mediated, and acted as lead counsel in numerous arbitrations and lawsuits involving IP matters of all types. He serves on the National Mediation Panel for the Federal Circuit Court of Appeals, in addition to being on numerous other panels, including those of the AAA, ICDR, CPR, and others. He was appointed by the ABA as an advisor to the drafting committee of the Uniform Information Transactions Act, and has been listed in the Legal 500 and Super Lawyers many times. Next down the line is Ray Bender. Ray that is my phone. Will you just shut it off at the... Sorry. Yeah, I have my phone on as a timer for the debates, but it didn't help. Mr. Bender's on the arbitration rosters of numerous organizations, including the AAA, the ICC, CPR, ICDR, and he's also on ICDR's roster for aerospace, aviation, and national security disputes. He is on the board and on the executive committee of SVAMC. He has also been an adjunct professor at Washington College of Law, American University, where he taught ADR law, an adjunct professor at the NYAW School of Advanced International Studies at Johns Hopkins University, where he also has taught courses on international telecommunications, and he's currently a member of the International Arbitration faculty for the International Law Institute in Washington, D.C. Now, before we start, I'd just like to make a few comments about CLE credit. Oh, Well, we can't last but not least, Richard Ziegler. Richard is an experienced international and domestic arbitrator and a certified mediator. In recent years, he has served on over 60 arbitration tribunals administered by the ICC, the ICDR, the Hong Kong International Arbitration Center, CPR, AAA, and others. He has previously been general counsel of 3M Company, where he led a department of more than 120 lawyers in more than 20 countries. And before that, he was a litigation partner in the New York office of Cleary Gottlieb and also of Jenner and Block. He's a member of the College of Commercial Arbitrators, is on the board of directors of CPR, and chaired its task force that wrote CPR's, quote, annotated remote procedural order for remote video arbitration proceedings. So as you see, we have a distinguished panel. Just to make a few comments about CLE, those of you who are here in person should have received a CLE sheet, but if you didn't, you can get it over there. Just fill it out on your own and turn it in, or you can send it in later at your leisure. For those of you who are online, you should have received in your virtual materials a CLE sheet. And again, several times during the program, we will announce a code, or there will be a code announced online. Just take notes of those codes and put them on the form and send them in when you can. So next, I would like to just describe the debates and the rules. It's a little different. The first debate is on the following proposition, quote, resolved that the proposed UNCITRAL draft rules for tech cases should be adopted as they provide a better way to hear tech arbitrations. Now, before the start of the debate, we will take a poll, which means in a few minutes, of the audience to determine who is in favor of this resolution and who is not. And even if you don't know much about the UNCITRAL high-tech rules, go ahead and give a shot at a vote. After the debate, we will take a second poll, and the person in the debate who changed the most minds wins the debate. And I can tell you people have been assigned to things they didn't necessarily want to be on, but they're taking what was assigned to them. Time-wise, each debater will have 13 minutes for his presentation in chief, or her, and 2 minutes for rebuttal. I'll keep time. That's 15 minutes per side, per debate, so half an hour total each debate, 2 debates, 1 hour. We've allotted an hour and a half for this program. I've taken a few minutes, but we'll still have about 20 minutes at the end for questions and answers. So to start the first debate, I'm going to repeat the resolution and ask everyone either online or in person to vote. Now, in person, you're going to raise your hands. Online, there is a polling function. Tap the polling function underneath your screen and you'll get a yes or no button. So I'm repeating again the resolution. Resolved that the proposed UNCITRAL draft rules for tech cases should be adopted as they provide a better way to hear tech arbitrations. All those in favor of this resolution now vote yes. Well, we have, who's counting here? I got 1, 2, 3, 4, 5, 6, 7 yeses. People online will have been noted. And without any further ado, I will then turn it over to Dr. Agris. Huh? Oh, well, I presume everybody else is no. Okay, we'll take the no's. No? Okay, 1 no, and a lot of undecideds. Okay. And so I'll turn it over to Dr. Agris to start the first debate.
Okay.
It's a little tight here, so.
It's okay, I got that. Okay, I think this works. Well, thank you for the introduction, and thank you to the organizers of this event. I'd also particularly like to thank SVAMC for their role and including me in this program. Now, it looks as if just given the number of yeses and the number of undecideds, I do have a little work to do, so here goes. Now, before launching into my argument, I would like to provide some background as to how these draft provisions came into being. Apparently, discussions regarding UNCITRAL specific rules for technology disputes was brought under the initiative of the Israeli and Japanese governments. There was a concern that arbitration was being underutilized in technology disputes since ADR mechanisms were not tailored to their needs. Now, this sector is highly technical, which is why it's called high tech, and specialized and populated by many small and even micro entities. So given its nature, time is of the essence. Disputes that take a long time to resolve can have an adverse effect on funding, and furthermore, particularly where there are limited resources, resources spent on addressing these issues prevent the entity on improving their brand and crucial time for R&D or marketing. So today I would actually like to, and I'm going to pull the slides up, focus on draft provisions 3, 5 to 7, which focus on unique issues encountered in technology disputes. And I will also briefly touch on provisions 8 and 9. So I am, just as a warning, going to be jumping around a little bit. But my first, the first draft provision I want to talk about is draft provision 6 and 7, and these are covered in slides, just for reference, slides 8 to 11. And these deal with confidentiality. I'm talking about this first, since in my view, these provisions are particularly important reason for adopting these draft provisions. Now, this issue is not really addressed in the UNCITRAL rules currently in effect. I would, though, like to note that in a White and Case study conducted in 2018 on international arbitration, 87% of the respondents stated that confidentiality in international commercial arbitration was of utmost importance, and 74% of the respondents stated that confidentiality should actually be an opt-out rather than an opt-in feature. Provision 6, which is up on the slide and it goes on to the next slide, relates to outbound confidentiality, which specifically prohibits the disclosure of information regarding the arbitration and generated to parties not involved in the proceeding. And furthermore, I'm going to go to the next slide. Provision 5, actually of the draft provision 6, addresses concerns regarding protection of ESI, which is definitely on the minds of a significant number of potential users. 2021 White and Case study, a later one on international arbitration, indicated that 30% of the respondents stated that a disadvantage of virtual hearings, a platform which is here to stay, are confidentiality and cybersecurity concerns. And this issue is actually addressed in, as you can see, in paragraph 7 of draft provision 6. Now, another provision of these proposed rules is draft provision 7, which actually relates to inbound confidentiality. And this aims to protect sensitive information within the arbitration, which is actually disclosed during the proceedings, such as trade secrets, sensitive financial information, proprietary information. And this is information disclosed not only during the hearing, but in discovery in the run-up to the hearing itself. Now, some of the arbitration rules do address outbound confidentiality, like the CPR and the AAA patent rules, and the ICC rules actually does address it in Article 22 in a rather vague manner, and just it states, upon request of any party, the arbitral tribunal may make orders concerning the confidentiality of the arbitration proceedings or of any other matters in connection with the arbitration, may take measures for protecting trade secrets and confidential information. So this is rather loosey-goosey and vague. Now, only WIPO Articles 67 to 70 actually specifically address confidentiality, and just it should be noted that these were actually the basis for these draft provisions 6 and 7. However, the WIPO arbitration rules only deal with IP disputes and are administered by WIPO. So there, for ad hoc international commercial arbitrations, there is really nothing that addresses particularly inbound, either outbound or inbound confidentiality. Now, in contrast, draft provision 7, as you can see, provides a very detailed roadmap, and additionally, as pointed out in the notes accompanying these draft provisions, and they're actually in your CLE materials, the existence and scope of confidential information is generally determined by applicable law and by choice of law analysis. And as you can imagine, this can be rather challenging when there are multiple jurisdictions involved. Now, I'd actually like to shift gears a bit and talk a bit about how these draft provisions address the technology aspects and the use of experts. And I will first talk about draft provision 3, which is the case management conferences, and which is very nice because the case management conference actually immediately puts the technology aspect of the dispute center stage. And these issues are not dealt with in the regular UNCITRAL rules. I actually want to call your attention particularly to paragraphs 2A, D, G, D, F, G, and H, which I might note deals with the appointment of experts and their role in technology disputes, which brings me to the next provision that I want to discuss in slides 6 and 7. And this deals with appointing experts. Actually, let me see. I'm sorry, this is draft provision 5. And now, one thing that draft provision 5 discusses is that the tribunal has the capacity to appoint independent experts, and that there's certainly nothing new. And Article 29 of the UNCITRAL rules deal with that. However, experts play a special role in technology disputes. And draft provision 5, as you can see, provides much needed guidance. And I'd like to point out particularly in paragraph 1 of draft provision 5 provides that an expert may assist with matters involving details and scope of technology and dispute, and further provides expert determination on some issues. So and this can be very helpful where time is of the essence. So essentially, an expert in technology under these draft provisions could provide guidance as to how a matter could be simplified, and it provides the means for doing so. I also want to note that paragraph 2 of draft provision 5 gives valuable guidance as to points that need to be considered and what direction needs to be provided to an appointed expert with respect to technology matters, such as the experience of the arbitrator and the need for technical expertise. Now, I also want to point out that the technology-related disputes are specifically addressed in draft provision 8, which goes to presenting evidence at the hearing itself. So you can see that paragraph 2 states that the tribunal could order evidence be taken, or an experiment could actually be conducted at the hearing, and that an expert can be involved. Now, in the time remaining, I want to address draft provision 9, which relates to a period for making an award. Now, although the timeframes are tight and may want to be revisited, the general idea of default deadlines and penalties for non-compliance can be extremely helpful when time is of the essence. So to summarize, I believe that for the most part, the proposed UNCITRAL draft rules for technology cases should be adopted, as they provide a much better way to hear technology-related arbitrations. They address the particular need for confidentiality for disputes and such mechanisms for instituting such measures. And this is particularly with respect to inbound confidentiality. And they also provide guidance regarding the role of experts in such disputes, and also are cognizant of the time-sensitive nature of certain disputes in this area. I would also like to add that adoption of these rules may provide motivation for other arbitral institutions for formulating guidance and or rules specific to technology-related disputes. At this point, there are only the WIPO rules, which I mentioned before, which is specifically directed just to IP disputes, and also the CPR arbitration and AAA arbitrate patent and trade secret rules, both of them directed to that. But those rules were formulated in 2005 and 2006 and aren't really referred to a whole lot. And so I think that this would stimulate dialogue across the route and hopefully action across the board in the ADR community. Thank you very much, and I'm going to yield to Mr. Graff. And I made it under my time too. So.
Yeah.
Okay. I'll just let you get out.
Well, I'm not going to dispute that there is need for speed, confidentiality, and technical expertise in dealing with technology disputes. The issue that we're dealing with, however, is whether these particular rules are helpful or get in the way. And I believe they get in the way. And I want to focus first on draft provision 1. I can get this thing go in order, which is the definition of what constitutes a technology dispute. And it is a dispute arising out of or relating to the supply, procurement, research, development, implementation, licensing, commercialization, distribution, financing, as well as the existence, scope, and validity of legal relationships of or related to the use of technology. And they include issues of ownership, licensing terms, payment, financial issues, non-competition, and confidentiality or regulatory issues. Now, what does all this mean? It means that there's a broad range of issues in technology disputes, some, but by no means all, of which may involve technology, some of these disputes may not require any knowledge of technology at all. They are essentially commercial disputes which have a technology element. And I recognize that you may need special provisions dealing with the technology element, but I don't agree that you need a whole set of rules. That's not this debate, that's the next one. But I want to focus on these particular rules and discuss whether they're helpful or not, keeping in mind that these are commercial disputes involving a whole range of issues that have nothing to do with technology as well as technology. And the way it's drafted, this rule would govern the entire dispute. Now, with that in mind, we talk about timing and the need for speed. Let's go to rule, well, first of all, let's go to rule 2, very simple rule. Unless otherwise agreed by the parties, there shall be one arbitrator. Now, given the definitions that I just read to you, is the default rule to be one arbitrator to handle disputes of that sophistication and difficulty? Now, the UNCITRAL rules in general, Article 7, provide for a default rule for 3 arbitrators. The parties can agree to one, but that is not the default rule. And I submit that one arbitrator to handle many of these disputes, if not most of them, would present a great deal of difficulty for that particular individual as to fill that role, and is not as likely to lead to a good result. We all have experience, I think, for those of us who do arbitration with single arbitrators. There's no appeal. It's a lot of times a bit of a crapshoot. Getting the right person, if you get the right person, it's great. If you don't get the right person, or that person runs into a wall, there's no one for them to talk to, or him or her, it presents a problem. 3 arbitrators, to me, if you can afford it, and if the case justifies it, and most of these will, should be done by 3 arbitrators. But let's go to the specific rules dealing with time frames. This is the rule entitled time frames, but it only talks about one thing: a supplement to the notice of arbitration. Now, there's no other mention of a notice to arbitration anywhere in these proposed rules, but it has to be communicated for a supplement to a notice of arbitration within 5 days following the initial case management conference. Where that came from, why 5 days, nowhere discussed in the documents or anything about it. 5 days, totally arbitrary. But it must include, in any case where evidence is offered, must include the evidence. All supporting evidence must be communicated within 5 days of the claim. If there's going to be live witnesses, you have to provide a list of all your witnesses within 5 days. Now, there's nothing in the notice of arbitration itself which requires any of this. It just seemed to come out of the blue. You have to have all your evidence, and you have to submit it when you make a supplemental. Why? Where did this come from? Strikes me as being completely arbitrary, out of the blue. Article 3 of the UNCITRAL rules, for most cases, there's no requirement for evidentiary materials or list of witnesses, anything like that in the notice of arbitration. All you need is a brief description of the claim and an indication of amount involved. That's all you have to put in your notice of arbitration. Why do you need to have your entire case in the notice of arbitration if it's a supplemental arbitration? Where did that come from? I don't know. It's the only provision under timeframes. But there's another provision which deals with timeframes, even though it's not a timeframe provision, and that's Article 9, Provision 9. Okay. And this provides that unless otherwise agreed by the parties, that is, both parties must agree, the award shall be made if it's on a written statement without witnesses within 20 days of the constitution of the arbitral tribunal, less than a month to reach a decision. Okay, if there's going to be witnesses or evidence, 40 days, all right? But you can extend it. Section 2 says you can extend it, but the extended period of time shall not exceed a total of 60 days from the date of the constitution of the arbitral tribunal. Remember the definitions I read to you at the beginning. How many disputes of that complexity and difficulty do you think can be resolved adequately with due consideration, hearing and considering the evidence in 2 months, not in 2 months from the date the arbitral panel is constituted? 2 months. And that's the maximum extended period of time. And if it's not rendered within that period of time, the arbitrator pays. That's right, the arbitrator pays for a delay of 14 days, 20%, 15 to 30 days, 50%, 31 to 60 days, 70%, delay of more than 60 days, 90%. No excuses, nothing like that. Where did this come from? Now, the UNCITRAL rules have a provision for expedited arbitration. It's rule expedited rules, a special set of expedited rules, and they have an Article 16, which is clearly the basis for this. A lot of the language is similar, except that the default period is 6 months from the date the tribunal is constituted. Can be extended to 9 months, not 60 days, if there's a problem. And if the arbitrators have a problem dealing with that time limit, they can come to the panel, they can come to the parties and seek additional time. Not that they have to pay out of their pockets. Now, I'm a professional arbitrator. I'm not going to agree to sit on one where if I'm delayed, if I get sick, if something happens and I can't render an award within 60 days of the date the tribunal was first constituted, it comes out of my pocket, whether it's my fault or not. Totally unworkable, totally unworkable. So let's look at some of the other provisions. There are provisions for appointment of experts, and that's very good. And there's one in the UNCITRAL basic rules as well. But let's take a look at the specific provision. All right, provision 5. And I want to go down to paragraph 9. Is it on that page? It's there, it's right at the bottom. It's hard to read. I'll summarize it quickly. The parties may agree on, or the arbitral tribunal may direct that the expert issue what's called a contractually binding expert determination. In other words, you can agree to have the expert, rather than the arbitration panel, issue a decision. And that's something called contractually binding. Now, I don't know what a contractually binding third-party decision is, but the rule makes clear it's not an arbitration award. How is it enforced? Who made the contract? The arbitrator appoints an expert, and that expert issues a contractually binding decision on the parties. Is that due process? How is it enforced? Who enforces it? Is it enforceable under the New York Convention? I don't see how. It's not an arbitration award. Where do you sue and what's the remedy? There's no right to appeal. An arbitrator, a third party, an expert, a third party, not the arbitrator selected by the parties, renders a final and binding determination on an issue. Radical new type of arbitration, only in this type of case, with all these commercial issues that have nothing to do with technology. And what is there about technology that justifies such a rule? I don't know. You tell me. But let's talk about provision 6, confidentiality. Very important. There is no arbitration rule that I'm aware of other than the Swiss, which has a presumption of confidentiality. And this, I'm talking about external confidentiality. Dr. Agris mentioned that. This is everybody in the arbitration, including people who are not the parties, cannot discuss anything about the arbitration or disclose it to anybody. And I'm not talking about the awards or orders or the existence of the arbitration. It goes beyond that. All materials produced in or generated during the proceedings which are not otherwise in the public domain, including materials created for the purpose of the arbitration. All other documents or evidence given by any party is cloaked with confidentiality. That means, unless both parties agree to waive it, nothing that happens in the arbitration, no evidence that is presented in the arbitration can be disclosed to anybody. And that means the shareholders of the parties, it means other people, creditors, other members of the public who may have a legitimate interest in knowing some facts that came out in this arbitration, all of that is automatically confidential unless both parties agree to its disclosure. Oh, boy. Okay. I just want to talk about provision 7, if I have a chance. Confidentiality provision, paragraph 5. This is internal confidentiality. Look at paragraph 5. It gives the arbitrator the power to render a decision on the merits based on confidentiality that has not been disclosed to the parties. All right. Anybody have a problem with due process in that? Article 29 of the UNCITRAL rules gives the arbitrators the power to make decisions on confidential information, but provides a party shall be entitled to examine any document which the expert has relied on in his report. You can't render a decision based on material that's so confidential that you haven't had as a party the right to see it. That prevents due process. So in other words, summarize, these rules are hastily drafted, ill-considered, arbitrary, and go far too far in cloaking matters with confidentiality and imposing undue time restrictions. Thank you.
Now each party has the right, if they wish to use it, for a 2-minute rebuttal. So Dr. Agris, if you would like to use your 2 minutes.
I suppose so. I wish I had more than 2 minutes to rebut this, but I'll do the best that I can, and I'll try and take it point by point. I think the first point was with respect to the definition and the broad definition, and if if you look at the notes that accompanied this, the intention was that it encompassed, that it gave the parties a choice, and a wide range of parties the choices to whether they wanted to use these rules or not. Certainly, and as Mr. Graff said, some of them might be specifically commercial. So if the parties decide they don't want to adopt the rules and that there isn't much of a technological aspect, they certainly are more than welcome to do so. Now, with respect to one arbitrator, a big concern with respect to arbitration is the cost involved. And when you have 3 arbitrators, that's a lot of money. And when you have for technology disputes where you have startups or micro entities, it's better to actually have one arbitrator as a default. And certainly the parties, it doesn't prevent the parties from choosing to have 3 arbitrators. So it's not like one is prevented from doing so. Now, supplementing with respect to Article 3 and supplementing the notice of arbitration, I mean, certainly the 5 days that is concerned, but the whole object of these rules was to have a mechanism that was very, very fast. And so the reason why you actually didn't just come out of thin air, it's to really expedite things and to have this done very quickly. And so I would think that if the parties had chosen to adopt these rules, they certainly are well aware of having to do that. So that's some. Okay. The other thing is with respect to, I'll go to the most important thing with respect to the confidentiality. And this is actually saying that you can't disclose it to anybody. Now, actually, draft provision 6 with respect to that actually provides exceptions, and there are a number of them. This is to enforce and to comply with provisions and to any other governmental body and to a professional or any other advisor. So it's not like they can, they're barred from disclosing to anybody. There actually are exceptions. So I'm okay. Am I out of time?
You're right.
Oh well, as I said, I wish that I had more, but this is the best that I could do here.
George. I know 2 minutes is not much time,
It
but we're
isn't.
having two debates. So.
It really isn't.
All right, so I'm not going to rehash all the details. My point is that, yes, I think it's a good idea to have special rules for cases with technology in them, but they have to be considered and they have to be well thought out, and they have to be planned so that you can get an adequate decision without running into undue obstacles. The examples I mentioned of the people who can't get disclosure are not included in the exemptions in the statute. Stockholders can't be informed of what happened in the arbitration. Creditors can't be informed. Other parties who may be interested, third-party financiers, you talk about small companies who are bringing them. You can't tell them what happened in the arbitration. I mean, it is unduly restrictive, unnecessarily restrictive, and no other arbitration rules have it. If people want to have the ability to have a good set of arbitration rules that govern high-tech disputes, draft a good set of rules to govern those disputes. And it has to be well drafted, well considered, and this isn't it.
Thank you. A minute under on that one. Okay, so we're going to now take a second vote on the resolution and see how many people have changed their minds. So I'm going to read the resolution again, and we'll take a vote. Quote, resolve that the proposed UNCITRAL draft rules for tech cases should be adopted as they provide a better way to hear tech arbitrations, close quote. All those in favor of this resolution now vote yes. All those opposed? All those undecided? I would say certainly within the room, the votes have switched. How about, what are you getting from online, Lisa?
Yeah, that's it.
Anyway, given the time constraints, we'll go ahead and that'll come up. I think I can safely predict, based on the in-house present vote, that the winner is Mr. Graff. And I have to say, in fairness, I think he had the easier side.
Yeah, he did have these. I mean, I've got to admit, I mean, you know, I keep saying, but now that we're done, but yeah, I agree with a lot of what you said.
So the second debate, well, now the resolution for the second debate is as follows. Quote, resolved that high-tech disputes can best be resolved on the written memorials and documents, with the tribunal then deciding, in conjunction with the parties, which witnesses the tribunal wishes to hear. And we have two versions of this, which is going to make it even more complicated. I don't know if the debaters still did this, but we talked about doing a version with the written memorials, including witness statements, and another with not even witness statements, but however you want to debate it. So in any event, do I need to repeat the resolution? I'll repeat it one more time. Will you repeat it? Okay, and then Mr. Ray Bender will take the pro side.
Maybe you could take that off the screen. I don't know.
Sure.
All right, good afternoon. Thank you, Bill, for that introduction and for moderating today's debate. The resolution we're debating today, Richard and I, is as follows: that high-tech disputes can best be resolved on written memorials and documents, with the tribunal then deciding, in conjunction with the parties, which witnesses the tribunal wishes to hear.
We now need a vote on that.
Yes, go ahead.
And so who is in favor of that resolution? Got two. Who's opposed?
Four.
Four? One. You count them 1, 2, 3, 4, 5, 6, 7.
Okay.
All right.
Mine have 60 in favor, 60% in favor, 40%
resolution.
Okay.
So
All
positive.
right, so please, go ahead.
All right, so let me make a preliminary observation. Why should this proposition relate or apply to high-tech disputes as opposed to any other dispute? Well, I think George and Cheryl did a good job in describing what high-tech disputes are. But let me talk a little bit about the characteristics of high-tech disputes. First, high-tech disputes tend to be, or at least often are, highly complex, and the dollar amounts in controversy are often substantial. As a result, this suggests that the arbitration process may be different in certain respects. It may be more extensive. We may have more lengthier hearings, and that in turn, the complexity suggests that there may need to be some reasonable procedures in a given case to streamline the arbitration in order to achieve efficiencies and cost savings. Second characteristic of high-tech disputes is that they normally involve or often involve international or cross-border disputes. Technology doesn't stop at the borders, and transactions typically don't stop at the borders. So keep in mind during our discussions that we're not only talking about U.S. domestic arbitration, but international arbitration as well. Third characteristic, high-tech disputes often include the testimony of expert witnesses on one or more issues. So there could be scientific experts in the areas of aerospace, chemistry, biotechnology, IT and communications technology, patents, or many other specialized areas in the high-tech fields. Now, many arbitrations will have accountants testifying or other experts in damage calculation, but it's another level or order of magnitude when you're talking about expertise in high-tech resolutions. Now, Richard and I may make some comments about expert witnesses, but I think for the moment I'm going to focus my discussion on fact witnesses testifying in arbitration. So as I look at this resolution, there are two elements that drew my attention. The first one was the idea that high-tech cases can best be resolved by written memorials and documents. That would include written witness statements, as opposed to witnesses appearing live and testifying orally. Second feature of this resolution is the idea that lawyers would no longer unilaterally decide which adverse witnesses they can call for cross-examination. But instead, the tribunal, in conjunction with the lawyers, gets to decide which witnesses should appear at the hearing for cross-examination. So let's discuss each of those points in turn. First, written witness statements. Putting a witness's direct case testimony in writing form for fact witnesses means essentially that the witness would reflect the detailed testimony that the witness would give orally by putting it in writing, including references to documents, which also would be presented with the witness statement. Statements are normally signed by the witness, and usually there's an affirmation by the witness that the facts in the witness statement are true and correct. The use of written witness statements for direct case of fact witnesses is neither unusual nor controversial in international arbitration. In fact, it's the prevailing practice in international arbitration. With respect to domestic arbitration, there is still a bit of resistance from U.S. practitioners and also from domestic lawyers who may not, domestic arbitrators, who may not be familiar with international practices and who are more comfortable having witnesses presented for oral testimony using the old-fashioned Q&A format. Let's look at the advantages of using written witness statements. First, presenting the direct case of a witness in writing can save considerable hearing time and thereby achieve efficiencies and cost savings, which are hallmarks of arbitration. This is especially true in high-tech cases, which often can be more complex and time-consuming than your garden variety commercial dispute. Second advantage to the use of written witness statements, it permits everyone involved in an arbitration to be better prepared for the hearing. And that would include witnesses. Some witnesses are not comfortable getting out and their rhetorical skills are not very good. They could be confused or disorganized having to give testimony live. Written witness statements help them organize the presentation of their testimony. Opposing counsel as well gets a benefit from having written witness statements, because instead of guessing what a witness is going to testify to and having to make up cross-examination as you go along at the hearing, they will get the witness statement typically 2 weeks or so in advance of the hearing, and the opposing counsel can prepare much better for cross-examination. Arbitrators too. As an arbitrator, I've often sat in hearings where there's direct testimony, and I'm wondering what the witness is going to testify to, and things may come as a surprise to me. Whereas if you have written witness statements ahead of time, as an arbitrator, you get a much better sense and can follow along the witness and know precisely what the witness is going to testify to in advance. There are some criticisms of written witness statements. First, that witness statements are usually drafted by lawyers. That's the first criticism. Second, the witness statements deprive arbitrators of the ability to assess the witness credibility on direct examination. And also that witness statements may not be the best way to persuade the tribunal of one's view of the case. For example, in a typical situation or in one situation, you may have to put a witness who's given a written statement on the stand and immediately turn that witness over for cross-examination by an aggressive or hostile opposing counsel for cross-examination. And lawyers don't like that because it sets a bad stage by introducing the witness in a defensive posture before the arbitrators. But there are good answers to each of these criticisms. First, lawyers usually do draft statements of their witnesses, but generally only after an interview with the witness to make sure that the witness is comfortable to the facts that they're testifying to. This process is really not unlike a lawyer preparing a witness for oral testimony. In my experience, both attorneys and witnesses take the job seriously, and they put down on their written witness statements truthful statements and statements that really present their case. I think a lawyer in this context has an obligation to warn the witness that they will be subject to cross-examination, rigorous cross-examination by the other side, and also questioning by the arbitrators. And a witness who does not take a witness statement seriously or has a cavalier or careless attitude about that witness statement can lose all credibility before the arbitrators. So again, that's the first answer. Second, 2 minutes. All right. With respect to assessing witness credibility, arbitrators have other opportunities to do that. Cross-examination, redirect examination, recross, and questioning by the witnesses. So there can be exceptions, and the exceptions would relate to, for example, a witness who is a key witness in a case whose credibility is important, could be outcome determinative, and in that case, parties should have the right to have a witness testify live. So my conclusion from all this, the resolution we're debating, is that it is the best method for presenting a case, but there could be exceptions, and counsel ought to be given that opportunity. The second component here of this resolution says that where there are witness statements that essentially rather than having a lawyer decide who the witnesses that appear for cross-examination, it could be a shared decision between the tribunal and the parties. I think this component is a little more controversial than the first aspect I discussed. Today, most international arbitration rules envision that witnesses would put on written witness statements coupled with the right of opposing counsel to cross-examine. So some of the rules provide, for example, the Stockholm Chamber of Commerce rules, that if witness testimony in written form is used, that the witness shall attend the hearing. The ICDR rules is not exactly that, but it comes close to that the witness shall. In fact, some rules, like the WIPO rules, suggest that an arbitrator can condition the use of written witness statements on the witness appearing for cross-examination. A couple of sets of rules, like the IBA rules and the ICDR rules, suggest that an arbitrator could consider a witness statement, even if the witness, for good or valid reason, in exceptional circumstances, fails to show up. That's, I think, a little extreme. So bottom line, and the difficult question here, is whether or not an arbitrator, if a counsel wants to cross-examine a witness, can an arbitrator unilaterally decide? I think the answer is no. I think this resolution simply puts the matter in conversation so that rather than unilaterally decide, that the arbitrators or the tribunal gets to be a part of the discussion and can, in conjunction with the parties, make a decision on which witnesses appear for cross-examination. Thank you.
Thank you.
Good afternoon, everyone. My thanks too to the organizers of New York Arbitration Week and Silicon Valley Arbitration Mediation Center for inviting me to have such a treat to take the opposite side of my colleague Ray Bender's support for this ill-considered proposition. So, and I gather I have the uphill battle given the 60-40 split already in favor of it. Here's a simple response. You can't cross-examine a written witness statement. And the problem with this proposal is not as Ray just put it. It simply puts the matter of whether there will be cross-examination in conversation so the parties can't unilaterally decide. It actually, the way I read it, the presumption, it's the tribunal's decision. Yes, they have to talk to the parties, but at the end of the day, under this proposition, a tribunal has the right to say, we don't want to hear from these witnesses. We read their statements. That tramples due process. If a tribunal actually implemented the authority that this proposal seems to give the tribunal, they would be risking vacatur of the award. Now you may say, like Ray, well, it can't really mean that. But if it doesn't mean that, why would it be phrased the way it's phrased? Today, tribunals are fully authorized to chat with the parties at a pre-hearing conference or otherwise and say, you know, we've looked at the witness statements. You guys put in 12 of them. There are a lot that seem cumulative. Some of these issues really don't seem to warrant us to have to decide them. Can't you get together and decide you don't really need to call all these people for cross-examination? That happens today. You don't need a special rule to authorize a tribunal to apply common sense in the management of a hearing. This rule reverses the status quo in two ways. First, it would provide that witnesses need not be called, absent some compelling reason to call them for cross. And second, it implies strongly, at the end of the day, the tribunal gets to decide. So I think those are worlds apart from current practice. If you don't believe in cross-examination, if you're a civil law heritage person, maybe 60% of our Zoom audience is calling in from overseas in non-common law countries, then this is your proposal. But if you're a common law lawyer and advocate, and you believe that cross-examination is the crucible on which truth can emerge, this is not your proposal. And let me just add a couple of more points. If you are counsel in an arbitration, this proposal is going to affect the way you prepare your case. Because if you know at the outset that you can't rely on being able to cross the other side's witnesses, and that your tribunal may decide, despite your best advocacy, that, yeah, we don't really need to hear from these people, you're going to change your way of strategizing your case. You might even, in a domestic case, when you would otherwise be content to rely on a witness statement in lieu of a deposition, you might think to yourself, well, I need a deposition, because how am I going to learn what the real scope of this witness's knowledge is and what this witness means by this, that, or the other, or what this document means, if I can't rely on the fact that I can examine this witness at the hearing? So I'm going to ask for depositions. And the other side may go through the exact same analysis. And so you end up with this proposal with both sides saying, tribunal, we agree, we need depositions in this case. So a proposal that is intended to streamline things and make things more efficient ends up risking the horror show of depositions in an arbitration. It's tough. frankly, for a tribunal, it's easy for a tribunal. If one side wants depositions, the other says, no, 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 to give a lecture to the side that wants it and says, you're in arbitration, we don't really favor depositions. You'll have a witness statement. But if both sides say we want depositions, it's much tougher for a tribunal to override what is the party's agreed upon procedure. There's another pernicious unintended consequence of this proposal when it comes to crafting strategy in a case. If you are in the not you, no one in this room, no one who's tuned in, whether from a civil code country or otherwise, but for some people who have nothing to do with this session, the subset of members of the bar who are, shall we say, aggressive when it comes to honor and ethics. If they're drafting a witness statement, and yes, of course, Ray, they will have hopefully interviewed the witness before they submit the witness statement to that person for signature. But if you think there's a decent chance your witness statement is going to be the be all and the end all in the case, because at the end of the day, there's this presumption that the case should be decided on pieces of paper, and your witness statement will not be subjected to the test of cross-examination. For that subset of less scrupled lawyers, you can imagine how that witness statement is going to be shaded, making the entire arbitral process inherently less reliable. So this proposal, I stipulate with Ray, I love written witness statements. I think they are efficient. I think all the reasons he articulates, if you haven't read the article that we shared of his in support of this debate, it's a great article. He gives the pros and cons. It's fair. He's a scrupulous lawyer. And on balance, witness statements make eminent sense, but witness statements that are not subject to cross-examination make no sense. Let me turn to the second point here. It's been an interesting debate on whether we need special tech dispute rules. I call them STD rules, because why not repurpose a familiar abbreviation? So tech cases are different in one key respect. They can be really complicated involving the technology, and it makes sense. And one of the virtues of arbitration is the parties get to choose an arbitrator that they think has expertise in the area. Frankly, I think specific expertise is much less important than comfort with challenging technological issues. And the providers and the SVAMC have responded to this need. You know, the SVAMC a couple of years ago did a study of users of arbitration, and the most important feature, benefit of arbitration was the ability to choose a decision maker with pertinent expertise. And there are now panels. Ray is on the Aerospace Aviation National Security Panel, the AAA ICDR. I'm a member of that panel. I think everybody in this table is a member of the esteemed tech list identified by the SVAMC. CPR has a technology panel. Once you pick your decision maker to your satisfaction, there is just very little difference between a tech case that involves biotechnology or CRISPR or artificial intelligence and any other complex commercial dispute. As George indicated when he read that ridiculously broad definition of tech cases that appears in the UNCITRAL proposed rules. Everyone in a complex commercial case, whether it involves technology or doesn't involve technology, if it's complex, you want the benefits of arbitration. You want speed. You want cost efficiency. You want flexibility of procedure. You want confidentiality and privacy protection. And you want the global enforceability that comes from an arbitration award governed by the New York Convention. You don't have to have a tech case to want those things. So STD rules strike me as quite unnecessary, but you don't have to agree with me on that in order to vote no on this proposition, because this proposition really strikes a dagger into the heart of due process. Thank you.
a dagger, you say. I didn't know I was debating William F. Buckley Jr. this afternoon, but that's something he would have said. Well, so I think that I don't think this proposition provides that an arbitrator or a tribunal can unilaterally decide what witnesses are called for cross-examination. I really think what it says is that the arbitrator gets to decide in conjunction with the parties. Again, as I read that, I look at it as there should be a conversation. It's instead of just unilaterally having a counsel say they need to cross-examine 20 witnesses, there should be a conversation. There may be some cases in that conversation where a witness's testimony is cumulative or very cumulative, or in another circumstance, a witness may be giving very straightforward testimony that really is historical or factual historically or background to a dispute. And really, there are not really any facts in dispute. And if there are such, a tribunal can really ask counsel whether in that case they need to cross-examine everyone that has submitted a witness statement. So again, I think the purpose of this is now to introduce the tribunal into the discussion, into the conversation, and that's kind of the purpose of it. I agree. I grew up at practice in the common law environment, and to me, the right of cross-examination is, in fact, a fundamental due process right. And civil lawyers don't see it that way necessarily. They put more credibility or stake into documentary evidence rather than testimonial evidence. So civil lawyers may not be as offended or taken aback by this proposal. But again, I think it's introducing into the question. There's an analog, and that is in the deposition world, which Richard mentioned. Oftentimes, parties will come in and say, we each have to take 20 depositions. Well, when you have a conversation and the tribunal is involved in that decision, the tribunal can kind of jawbone and say, no, you really don't need 20, or do you really need 20? Or the tribunal may say, okay, start with 5 each, and we'll come back later and see if you need 20 or 10 or more. But those kinds of conversations can be helpful, and they don't, again, get the decision being done by the tribunal. In fact, in those cases where parties agree, remember, arbitration is a creature of party agreement, arbitrators typically allow lawyers who insist to have the number of depositions they want. So again, I don't think this is that radical a proposition, but introduces the tribunal into the discussion.
Thank you, Ray. Oh, you do?
Latin cleanup.
That's right. Oh, I thought you already cleaned up.
Okay, so in my final 2 minutes, 2 points. One, if this proposal were limited to encouraging conversations between the tribunal and the parties on who should show up at the hearing to be cross-examined, then it's not very artfully crafted, because you don't need a proposal for that purpose, because that's the current status quo. So the only fair way to interpret this proposal is that it puts a thumb on the weight of the tribunal ultimately making the decision. And it certainly, I don't think Ray disputes this, puts a thumb on the scale of not calling witnesses. Secondly, I just want to clarify the importance of cross for those who are from civil traditions. It's not because you achieve a Perry Mason moment where the witness on the stand says, oh, you got me, that's all a tissue of lies. That happens sometimes. It's not really most of the time for credibility purposes. It's so rare that a tribunal's award turns on a conclusion that witness A is not credible and witness B is credible. But what it does do is it allows the examiner to elicit where the dispute really is. Cross-examination is incredibly efficient, because if you read a witness statement, you think there are 15 items of dispute. But after cross-examination, it turns out if you phrase it a little differently, if you tweak it this way or that way, the witness agrees, maybe reluctantly, that, yeah, we don't really disagree with that. It so streamlines the decision for the arbitrators to make. They won't even have to risk losing 90% of their compensation, because they get to do the award quickly. To reinforce this point of the value of cross, even if you don't get someone to look incredible or to make admissions. One quick war story. Personally, I'm an advocate. I'm in a hotel conference room in Geneva. The other side has called a Thai lawyer who has supplied a witness statement in writing in English on the applicability of Thai law to the facts of our case. In the course of the examination, in the first 5 minutes of the cross-examination, because we had live note, it became apparent that this witness could not read English. It was clear he couldn't understand or speak English because we had an interpreter. What we didn't know until he showed up live in this room in Geneva is he also could not read English, and yet he had signed a witness expert report in English. We took a break. Within a few minutes, it developed he hadn't written his witness statement in English. He had no idea what it said in English, and the case settled. So I rest my case.
Thank you, Richard. And excuse me, I've done that to you twice. So we're going to reread the resolution and take the second vote. So the resolution reads as follows, quote, resolved that high-tech disputes can best be resolved on the written memorials and documents, with the tribunal then deciding in conjunction with the parties which witnesses the tribunal wishes to hear, close quote. All in favor of that resolution, raise your hand or vote online. And 1, 2, 3, 4 in favor, probably civil law practitioners. Who's opposed to that resolution? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. And online, I don't know if we can get it immediately. If we don't have it in about 30 seconds, we'll go to question and answers.
38% yes and 62% no.
Okay, so the noes have it. So I guess, Richard, you win. But again, none of the panelists got to choose what side they wanted to argue. So at this point, it is 3:15. We started 5 minutes late, so I think we can go to 3:35, and we'll have 20 minutes for questions and answers. Lisa, who's sitting here and is online, will sort of weed out some of the questions that we receive online and relay them to us. But for people here, just raise your hand. We'll start here. And anybody has any questions? Yes, sir.
I have a couple of questions about the UNCITRAL rule. First question. Two questions. First question is, what is the function of that definition? What's the purpose? The second question is, what's the status of the consideration rule? How far along are they? How close are they coming down?
Yeah, well, I can.
I can try and answer both questions. With respect to your first question, I believe that the purpose of that rather broad definition, and I'll concede it is rather broad, was to be as inclusive as possible and not just involve the high-tech sector. So if other types of technologies wanted to apply these rules, they could certainly do so. So I think that was the purpose.
Sorry, that wasn't my question. My question is, what function does the definition serve? And where is the name of the term, the defined term being used? That, why do we have that term being defined?
Well, I think, I understand your question. I think the term is defined to see whether, I guess, these rules would apply to a particular subject area. So I think that was certainly why. Now, as far as where your second question, where these draft provisions are at Apparently, there have been subsequent meetings. I believe there is a meeting, and it's in the CLE materials in April and then in August, where it was just decided that it would probably be best not to actually adopt them as rules per se, but actually as guidance. So certain provisions could be used as guidance, and that could be actually included in the currently UNCITRAL rules in force.
We'll take a second question if there's one here, and then we'll move to online. But if anyone has one here, I'd ask you to come up to the mic because I think others can't hear, but if come on up to the mic.
Mike Chickia. First of all, thank you for the informing debate. What I want to ask is, actually, I think it's related to the cross-examination, but my first law degree is a civil law degree, and I still think that even those arbitrations seated in civil law jurisdictions, I think even they will be inclined to have cross-examinations, and I think cross-examinations are still an essential part of it. But still, like, in terms of this due process paranoia, what I want to know and learn is, if in these like high-tech arbitration disputes, so we appoint arbitrators that are experienced in these disputes, but would you allow them to do their own research? Like, and what will be the extent of this? Because yes, we appoint experienced, and those who are experienced in these like high-tech disputes, but what will be the extent of the research they could do on their own? And I'm not sure if you could cross-examine it, but maybe I want to hear your opinions on that.
Yeah. Well, on the first point you made, and that is that civil lawyers and civil systems also recognize cross-examination. That is true. And in fact, all of the international rules, as far as I can understand, and I've looked for this debate as at the Swedish rules, of course, the ICDR rules, the SEAC rules, the LCIA rules, and the IBA rules, and all of them recognize that cross-examination is a part of the system when you have written witness statements. There's been, in effect, a harmonization by the international rules between the common law system and the civil law system. So the answer is yes, they do. As for the question of how much do arbitrators do on their own research, even though we're experts, you might think we do, it's not really cool in arbitration for arbitrators to do their own research. We don't really do that. I mean, we go as far as looking at cases that parties give us. I will, if I don't understand a case, I'll look what's in the case, what's cited in that case, other cases from a jurisdiction, and I'll read those as well. And I think that's a fairly standard way of doing it. But we just typically do not do our own factual or even legal research, except for as I indicated, by drilling down on cases that are provided to us. So there's really not much scope for arbitrators, high-tech or otherwise, to be doing their own research. I will say that high-tech arbitrators do bring an expertise to a particular high-tech dispute, because hopefully when they're appointed in the recognition that they have some area of expertise. Richard and I are on the aerospace and the aviation panel of the ICDR, for example, which suggests we have background in aviation. So we bring that to us. But in terms of doing our own research in a given case, no.
Lisa,
300%.
just maybe to keep it moving, unless we have, because I think I agree with what you just said. Can you come up and speak into the mic and pass on one of the questions from Zoomers?
Well, first of all, thank you, everyone. Very interesting debate. I have a question here from Liliana Rodriguez Rodamoso, arbitrator roster at the Chamber of Commerce of Bogota. She has a two-part question. First, what would you consider an appropriate set of rules for tech disputes? And relatedly, what are your favorite set of the existing rules for technology disputes? Thanks.
You can answer, and then I'll also like to answer.
I think that one of the rules here, which I did not mention because obviously I'm gone, is the rule describing very well what would happen, for example, in a preliminary conference in a high-tech case. Those kinds of issues. I don't know that you need a whole set of rules, but like a lot of the ICDR rules, for example, there's a list of things that are optional to be discussed. There's a special set of rules for preliminary conferences. I think they're called P or whatever.
Yeah.
The things that might be raised. And I think it would be very appropriate for high-tech cases to have a set of rules similar to, what is it, provision 3, which
Yeah.
lays out what can be discussed and should be discussed in a preliminary conference in such a case. And I think the answer is not to have a separate set of rules for the entire procedure, but to have a separate set of rules governing what should be discussed in preliminary conferences and what should be available, particularly in terms of court-appointed experts or tribunal-appointed experts, who I think can play a special role in technology, because no arbitrator, no matter how familiar he is with the subject matter, is likely to be familiar with the particular subject matter involved in this case. I mean, I get, and we all get requests to handle a case where they ask for expertise in some very specific chemical reactions or things like that. You can't expect an arbitrator to do that. All you can expect is an arbitrator who knows how to speak to an engineer, who knows when they're being fooled and when they're being not, and who is a quick study on technical matters so that they can really understand the issues and comprehend them. But the specifics very often are beyond that. If you have arbitrators who are not as specifically familiar with the technology, then a tribunal-appointed expert can be helpful. And I think a special provision dealing with that and how you do it will be helpful. Not mandatory, but something that can be raised in a particular case where it's justified in the preliminary conference and pursued by the tribunal and by the parties as a way to efficiently and effectively resolve the dispute.
Actually, I'll just briefly, and I agree with what George has to say, but the WIPO rules are actually very helpful, and they only cover patent disputes, but I think they provide a really good roadmap with respect to confidentiality and the preparatory, the case management conference. Another useful resource is actually the AAA patent rules, which really outlines like what ought to be covered in a case management order. That's all I'll add.
Richard?
As I tried to outline in my remarks, I don't think we need special tech rules. I think what's important is picking an arbitrator who's comfortable dealing with the technological issues. One issue we have in the world of both domestic and international arbitration, is this on?
I don't think it is.
Try this one.
All right, so I would suggest, Bill, that SVAMC put a debate on next year on whether there should be special tech dispute rules or whether that's not necessary. One issue I will say is that we live in a really decentralized world of arbitration, both domestic and international. There are so many sets of rules already existing. It's incredibly cluttered. You need a Rosetta Stone to compare one institution's rules against another, and they have subtle distinctions. So I would say it would all be a lot more efficient if we could just agree on a single set of rules, but hopefully not the UNCITRAL high-tech rules, because George certainly persuaded me that those are ill-considered.
We have a question. Rhea, if you come up to the mic. I don't think my mic is working, so I hope you can hear me.
Hi. As a second speaker, you mentioned the non-adversarial presentation of evidence in case the information is very sensitive. What alternative would you have if the party holding this evidence does not trust the confidential process because there can always be leaks?
This happens all the time in almost every case involving technology that I've been involved with, and in both litigation and arbitration, there's a procedure called attorney's eyes only. where the adverse party who might misuse the trade secret or whatever it is that must be disclosed, their attorney gets access to it, but the party themselves doesn't get access to it, but they have a representative that they trust who has access to it. It may be an attorney, or it may be somebody in their organization. I served that role in cases where in my firm, I wasn't the lawyer involved in the case, but they wanted somebody who can understand the technology to get in, look at the other side's technology, and either help prepare, either decide whether to challenge it or whether not to challenge it, and that sort of thing. But you cannot make a decision against somebody without giving that party knowledge of what the basis for that decision. That's fundamental due process as far as I'm concerned.
We have one more question, I think, and maybe one more in line, but if you would come up here, please, that would be great.
Good afternoon. I have a question regarding the time limits, because when I saw the slides, regardless of whether it's 20 days or 40 days or even 60, it seems more like an emergency arbitration kind of time limits. And looking at the definition of tech disputes, I don't see any reason for such rush. And I'm wondering whether you can see any reasons to proceed with such urgency. Thank you.
I'll address that, and I'll say, and well, George could, I'm sure he'll want to as well. And when I was preparing my part, that was a real challenge, because I as you can imagine, and I think that can be an issue. You know, that there might be for specific discrete cases where that 40-day might be. You know, might be useful, but I think like a longer time frame would be more reasonable. Like, for example, 60 days. But maybe I think, you know, previous rules had it that the arbitrator made the decision, and I know George begs to differ, but having something with teeth and making, you know, kind of putting the arbitrator's feet to the fire, probably I'm speaking against my self-interest, but probably might actually be a good thing where you know, time is of the essence.
Yeah, UNCITRAL has an expedited proceeding, and many other rules do, and they deal with that. These are much too short, though. They're just too short, and these are complicated cases, as everybody else has said, and very difficult to resolve in a 6-month expedited procedure under the existing UNCITRAL rules, and to have 60 days or 40 days from the date the panel is constituted, it can't be done.
Yeah.
I'm going to add one thing, but I'm going up here because my mic doesn't work. I noticed that these rules, and I think we're pretty much in agreement that these proposed rules are not the world's greatest rules.
Yeah.
But as I was looking at it myself, provision 9 says, except as otherwise provided or agreed by the parties, the award shall be made within 40 days, and they give ways to extend it. Well, one of the parties may have decided that the arbitrator is leaning against him or something, so you're not going to get an agreement to extend, and something happens to the arbitrator, whatever, it shall be made with such time. He doesn't make it, he's functus officio. The whole arbitration is wasted. Would that not be the case, I think? So that's one more problem with the rules.
Yeah, well, I think that's why they're probably not going to be rules, but discrete portions will just be incorporated as guidance in the currently existing rules.
Lisa, we'll take one more from online if you have it, and then we're done.
One last one from Michael Schneider. This may have been partly covered already about confidentiality. Concerning outbound confidentiality, what experience do you have with information or documents which is accepted as confidential, and how in such cases do the parties in the tribunal deal with the information which is accepted as confidential? Is the party that relies on the confidential information treated as not having proven the allegation which is supported by the confidential information? And if not, and the alleging party can rely on information that is classified as confidential and is not disclosed, how is the opposing party protected under due process considerations? Thanks.
Look, if you want to keep the information confidential, then keep it confidential. But if you want to litigate with somebody on the basis of that information, you have to grant limited disclosure.
Yeah.
You can put all the protections you want. The parties will negotiate a protective order. I always try to leave that to the parties. They usually do it because anybody experienced in this area does it all the time.
Yeah.
But if you have a choice, you can keep it confidential, but you can get in litigation with somebody where you want to rely on something that you keep confidential, and you can't do both.
Yeah.
Simple as that. You have to make the choice.
Yeah, you do. And you just put safeguards and protective orders can have various levels. And I know something that George mentioned, but sometimes I've been in situations where, well, certainly attorney's eyes only, and I was actually in one situation where certain information was only revealed to the arbitrators and the experts themselves, and it was in a room, and we could only take notes and not even photocopy. It was just such sensitive nature.
All right, well, I think we owe another round of applause to our excellent debaters. And we owe a round of applause to Eversheds for hosting this, and to Debevoise and Plimpton. Both of Juliana and Lisa have both done enormous work behind the scenes to make this come about, so thank you.